Exam Scholar, Real Estate Edition.
Question 1. Which of the following items could not be used by the owner of a hardware store as security for a loan, under the provisions of the Uniform Commercial Code? A. A personal note endorsed by him. B. Accounts receivable. C. Stock for sale. D. Equipment and fixtures. Answer. C. As the stock will be sold, it cannot be used to secure a loan. Question 2. A valid escrow requires which of the following? A. Escrow instructions with no conditions. B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party. C. The services of a licensed real estate broker. D. None of the above. Answer.
B. A binding contract between the buyer and seller and the conditional delivery of transfer instruments to a third party are required for a valid escrow.
Question 3. If the loan-to-value ratio is low. A. The equity in property is high. B. The equity is not affected. C. The equity in the property is low. D. None of the above. Answer. A. Loan-to-value ratio is the ratio of the loan to the appraised value. If a 90% loan-to-value ratio is given by a lender, that indicates a 10% down payment, and a beginning equity of 10%. If the loan-to-value ratio is only 60%, the down payment is 40% and the beginning equity is 40%. The lower the loan, the higher the equity. Question 4. Sellers are usually reluctant to cancel an existing transferable fire insurance policy in the event of a cash sale, due to the fact that A. A buyer may not properly cover the property. B. A higher short-term cancellation rate will apply. C. It could result in cancellation of other policies. D. The elimination of a cash return in the proration. Answer. B. A seller on a cash sale would be reluctant to cancel an existing transferable fire insurance policy because the seller would receive a short-term cancellation rate. Therefore, the seller would prefer to transfer the existing policy to the buyer. Question 5. A minority purchaser enters your office and states they are looking for, and interested in purchasing, a particular property in a minority neighborhood. You could legally assume that A. This person is testing you and your legal procedures. B. They are interested in that particular property. C. They are interested in owning a home in an all-minority neighborhood.
D. They cannot qualify to own property in a higher-priced area. Answer. V. Should any prospective purchaser enter your office requesting to see a particular property, you would assume they were interested in that particular property. Question 6. A subdivider and developer purchased considerable acreage and now plans to construct a tract of 40 homes. In arranging the financing for the new construction, the lender has agreed to advance part of the funds immediately and will release a set amount of additional money as each home is completed. The funds that will be forthcoming as construction progresses are known as A. Obligatory advances. B. Reconveyance funds. C. Release monies. D. Open and mortgage payments. Answer. A. This type of construction financing is referred to as obligatory advances or fixed disbursement schedule. Question 7. All of the statements below are true, except A. A grant deed may convey after acquired title even when such warranty is not actually written into the contents of the deed. B. A quitclaim deed may convey any right or title including fee simple title. C. A deed is of no effect unless delivered. D. A reconveyance deed is used to convey title to a new purchaser in connection with a trust deed sale. Answer. D. A reconveyance deed is given by a trustee to the borrower, known as the trustor, after a loan has been paid in full. The borrower records his deed of reconveyance to clear the loan lien from the record. Question 8. Which of the following is not a necessary element in the formation of a contract? A. Offer. B. Acceptance. C. Consideration. D. Performance. Answer. D. Two parties may enter into a contract, but they might not fulfill, also known as perform, their obligations. Question 9. Lenders use the term debt-income ratio to refer to A. Part of closing costs. B. Loan qualifying tool. C. Requirement of the federal government. D. Formula used in appraising property. Answer. B. Debt-income ratio indicates the fraction that your loan payment on the property is in relation to the net income from the property. This is used by lenders when qualifying a person for an income property loan and measuring their margin of safety. Question 10. A prospective client calls you and asks you to take a listing on his property. In reviewing his papers, you discover he is purchasing the property on a contract of sale that has no acceleration clause, and that has no provision in the contract prohibiting a resale or an assignment. Which of the following is the most nearly correct statement? Your client could A. Sell his interest in the property, but only if he pays off the contract first. B. Sell or assign his rights but not his duties under the original contract unless the contract seller's approval was obtained. C. Properly give the purchaser a warranty deed to the property providing the deed recited subject to the existing contract of sale. D. Properly give the purchaser a grant deed to the property, providing he took back a recorded purchase money second trust deed to cover the payments due on the original contract of sale. Answer. B. A party purchasing property under a land contract of sale may sell their interest without difficulty by assigning the contract, provided there is no prohibition on the agreement. The assignee would still be secondarily liable for some of the terms of the contract unless the seller's approval was obtained.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. Which of these instruments does not contain the interest rate, loan amount, term of the loan, and monthly payments? A. Mortgage. B. Deed. C. Lease. D. None of these? Answer. D. None of the listed instruments contain the interest rate, loan amount, term of the loan, or monthly payments. The type of instrument that does contain these is the note. Question 2. Anthony receives a tax bill that is related to cost per front foot and amount of benefit he receives. This type of tax bill would be called A. Eagle. B. Special assessment. C. Front foot assessment. D. None of these. Answer. B. Special assessments are generally repayment to the government for installation of curbs, gutters, and other enhancements. The cost of these is based on the amount of benefit that a particular property receives from the enhancements. Question 3. Retaining a property while at the same time using it as collateral to secure a loan is called A. Promissory. B. Hypothecation. C. Accretion. D. Collation. Answer B. The act of using property to secure a loan while at the same time retaining the use and benefit of the property is called hypothecation. Question 4. In which clause does it allow for a buyer to be free of recourse in the event of foreclosure? A. Ad hominem clause. B. Dispersal clause. C. Exculpatory clause. D. Extradition clause. Answer C. An exculpatory clause acts as a non-recourse loan. This means the lender can only look to the property for the satisfaction of the loan. The buyer is not personally responsible for the note. Question 5. Referral fees are legal to be paid if they are given to A. Licensed brokers. B. Licensed agents. C. Anyone. D. None of these. Answer A. Referral fees are legal to be paid only to licensed brokers. Question 6. The secondary mortgage market consists of which major participants? A. Fannie Mae. B. Ginnie Mae. C. FHLMC. D. All of these. Answer D. Fannie Mae, Ginnie Mae, and FHLMC are all major participants in the secondary mortgage market. Question 7. What does a general warranty deed contain? A. Covenants that warrant the new owner's undisturbed and clear title. B. Covenants that include provisions of a quitclaim deed. C. Covenants regarding quiet enjoyment. D. None of these. Answer A. Covenants that warrant the new owner's undisturbed and clear title are contained in a general warranty deed. Question 8. A general agent has full authority to A. Bind the principal to all agreements. B. Act as attorney at law. C. Act in the bounds of power of attorney. D. Only bind principal to agreements with written consent from the principal. Answer A. A general agent is a representative of a principal that has the full authority to bind the principal to all agreements. Question 9. The income approach to appraisal uses which kind of rate? A. Market. B. Capitalization. C. Index. D. Consumer. Answer B. The capitalization rate, or cap rate, is used in the income approach to appraisal and is an analysis of how much investors are willing to spend in a certain neighborhood in return for a certain amount of income. Question 10. Which of these is an example of a general agent that has the authority to make binding decisions on behalf of the principal? A. An attorney at law. B. A real estate agent. C. A real estate broker. D. A property manager. Answer D. A property manager is a good example of a general agent who has been empowered to make binding decisions on behalf of the principal. Question 1. A special type of appraisal used for property tax purposes is called A. An assessment. B. An appraisement. C. A survey. D. An estimate. Answer A. An assessment is a special type of appraisal used in determining property taxes. Question 2. If a tenant has been defiantly not paying the required rent to the landlord has the right to personally evict the tenant. B. Change the locks. C. Bring court action. D. Harass the tenant with phone calls day and night. Answer. C. In regards to tenant and landlord relationships, the Landlord-Tenant Act in most states has clearly defined court procedures with timelines for the eviction process. Question 3. Which of these is associated with a deed? A. Defeasible fee. B. Alienation clause. C. APR. D. Hypothecation. Answer. A. A defeasible/indefeasible fee is associated with a deed. The other listed choices are associated with a mortgage. Question 4. What does the term alienation mean? A. Recording of judgment. B. Prescribing of a lien. C. Transfer of title. D. Exclusion of passage. Answer. C. The term alienation means transfer of title. Question 5. The power of attorney means A. A broker is an attorney at law. B. A broker can execute contracts on behalf of the principal. C. A broker is able to sue in court. D. None of these. Answer. B. Of the answers provided, the power of attorney grants the broker the power to execute certain actions on behalf of a principal. Question 6. Although an agent working under a broker is an independent contractor, the broker is still responsible for A. Making sure the agent completes tasks on time. B. The legal licensing and ethical activities of the agent. C. Providing a safe and hospitable work environment. D. The assignment of tasks and duties of the brokerage. Answer. B. The broker is required by law to be responsible for the legal licensing and ethical activities of the agents associated with the brokerage. Question 7. What is the doctrine of caveat emptor? A. A code of ethics. B. A doctrine of tenant rights. C. Let the buyer beware. D. Must be signed at closing. Answer. C. Caveat emptor is a Latin phrase meaning let the buyer beware. Essentially, it proclaims that the buyer must perform their due diligence when purchasing an item or service. Question 8. Mark, the seller, did not disclose the special assessment that will be due to the new owner in the near future after the sale is made, even though Mark knew of this development beforehand. In this case, Mark A. has done nothing wrong. It is only the agent that is bound by disclosure. B. has committed fraud. C. has been unethical but not illegal. D. none of these. Answer. B. Both agents and sellers have the commitment to disclose any and all pertinent facts about a property. Question 9. If a broker shows a home to a potential buyer and they wish to make an offer on it, what legal responsibility does the broker owe the customer? A. Honest and fair treatment. B. Fiduciary duty. C. Confidentiality. D. Exclusivity. Answer. Because the potential buyer is a customer of the broker, the only obligation the broker has is to treat them fairly and honestly. There is no fiduciary duty. Question 10. What legally obligates the buyer to pay the broker's fee? A. The exclusive right to represent. B. The broker protection clause. C. The legal rights of fiduciary duty. D. The contract. Answer. B. Unless the buyer hires another broker and then buys a property, the broker protection clause obligates the buyer to pay the broker's fee. Question 1. What does an appraiser do? A. Establish market value. B. Establish estimated property taxes. C. Verify building codes are in conformance. D. Provide written documentation on the state of the property. Answer. The primary task of an appraiser is to establish an estimate of market value through the analysis of data. Question 2. What type of estate is an interest in real or personal property that is limited in duration to the lifetime of its owner or some other designated person or persons? A. An estate for years. B. A leasehold estate. C. A land estate. D. A life estate. Answer. D. The type of estate that is based on the lifetime of its owner or designated third party is called a life estate. Question 3. If a married couple purchases property as tenants by the entirety, neither can obtain a court order for A. Partition. B. Separation. C. Estimation. D. Accrual. Answer. A. Neither person can obtain a court order for partition when a married couple purchases property as tenants by the entirety. This is different than other forms of ownership by a married couple. Question 4. What is the best way to determine if a neighboring property is encroaching on another? A. Obtain a court order. B. Visually inspect the properties in question. C. Obtain a survey. D. Compare land maps of both properties. Answer. C. The best way to determine encroachment is to obtain a professional survey of the property lines. Question 5. Henry is the seller of his home, which was built in 1978. What booklet is Henry required to give a potential buyer? A. Environmental hazards disclosure. B. Lead paint information. C. Flood zone disclosure. D. Asbestos warnings guide. Answer. B. If Henry owns a home that was built in 1978 or earlier, he is required to give any prospective buyers or tenants a lead paint information booklet. Question 6. When a corporation holds title to land, under whose or what name holds the title? A. The Board of Directors. B. The shareholders. C. The corporation. D. The charter. Answer. D. Since a corporation is a fictitious person, the corporation holds property title in the name of its charter. Question 7. An African American family is looking to purchase a house. Their agent has been showing them properties for weeks, all of which are in predominantly African American neighborhoods. This would be an example of A. Blockbusting. B. Steering. C. Isolating. D. None of these. Answer. B. This type of behavior would be an example of steering and is in violation of the fair housing laws. An agent must show homes in any areas in which the client can afford. Question 8. One of the jobs of a property manager is A. Maintaining the property while managing finances. B. Settle disputes with neighbors. C. Personally evict tenants that have not paid rent. D. Operating a log of events on the property. Answer A. One of the major jobs of a property manager is to maintain the property while managing the financial side of the operation for the property owner. Question 9. If Ivan owns property but has no heirs or will when he dies at age 86, who owns the property thereafter? A. The next blood relative. B. The federal government. C. The state government. D. None of these. Answer C. In a case in which a person dies owning property but has no heirs or will, property ownership reverts to the state. Question 10. In a case in which a person dies with no will and no heirs to their property, this is called A. Reversion. B. Escheat. C. Accretion. D. Reverse ownership. Answer B. The state becomes the owner of a property if the owner dies with no will and no heirs through the power of escheat. Question 1. Typically, a penalty that a borrower must pay if the payment is at least 15 days late on a first mortgage is best called A. A late charge. B. A delinquent payment fee. C. A fee in contract. D. A penalty in date. Answer A. A late charge is a penalty that a borrower must pay if the payment is at least 15 days late on a first mortgage. This time frame can vary, but the most typical is at least 15 days. Question 2. If Lucia was looking to come up with a down payment for her loan and she put forth the idea of using her 401k plan as a source for the down payment, this would be A. An acceptable source for a down payment. B. An unacceptable source for a down payment. C. An acceptable source for a down payment as long as penalties are paid prior. D. None of these. Answer A. A 401k plan is an acceptable source for a down payment for most types of loans. Most times, pulling funds from a 401k plan prematurely will result in penalties. However, it is not required to pay these penalties in order to secure the down payment for a loan. Question 3. The best definition of a foreclosure is A. The legal process by which a borrower in default under a mortgage is deprived of their interest in the mortgaged property. B. The legal process by which a borrower relinquishes interest in a real property whether in default or not. C. The legal process by which a borrower is evicted from real property in which they hold interest, even if only one payment is late. D. None of these. Answer A. Foreclosure is best defined by the legal process by which a borrower in default is deprived of their interest in the mortgaged property. Question 4. A mortgage on a property that is considered to be the priority mortgage among any loans recorded against a property is best defined as A. A primary mortgage. B. A first mortgage. C. An anterior mortgage. D. A premier mortgage. Answer B. A mortgage that is considered to be the priority or first place mortgage among any loans recorded against a property is best defined as a first mortgage. Question 5. An income-based community lending model, under which mortgage insurers and Fannie Mae offer flexible underwriting guidelines to increase a low or moderate income family's buying power and to decrease the total amount of cash needed to purchase a home is called A. Fannie Mae's Community Home Buyers Program. B. Freddie Mac's Community Home Buyers Program. C. Fannie Mae's Income-Based Home Buyers Program. D. Fannie Mae's Disadvantaged Borrowers Home Buyer Program. Answer A. Fannie Mae's lending model that offers flexible underwriting guidelines to increase certain families' buying power and to decrease the total amount of cash needed to purchase a home is called Fannie Mae's Community Home Buyers Program. Question 6. In an exclusive listing, it gives the licensed real estate agent the exclusive right to sell a property. A. For a specified period of time. B. Indefinitely. C. Until the property is sold. D. Until the seller changes their mind. Answer. A. An exclusive listing allows for the licensed agent to have the exclusive right to sell the property for a specified period of time. It does not allow for an indefinite period of exclusivity. Question 7. This is a law requiring lenders and other creditors to make credit equally available without discrimination based on race, color, religion, national origin, age, sex, marital status, or receipt of income from public assistance programs. A. ECO. B. IACO. C. COA. D. None of these. Answer. A. The law that requires lenders and other creditors to make credit equally available without discrimination based on race, color, religion, national origin, age, sex, marital status, or receipt of income from public assistance programs is called the Equal Credit Opportunity Act, or ECO. Question 8. The term that is used in reference to FHA and VA loans and that are paid in addition to the 1% loan origination fee is called A. Discount points. B. APR. C. Interest. D. None of these. Answer. A. Discount points are any points, money, paid in addition to the typical 1% loan origination fee. Discount points are usually associated with FHA or VA loans. Question 9. The most common definition of a creditor is A. A person to whom money is owed. B. A person that owes money to another. C. An institution that originates loans. D. An institution that insures loans. Answer. A. A creditor is a person to whom money is owed. The creditee is a person that owes money to another. Question 10. In order for a real estate agent to determine the market value of a property, the agent would look at recent sales of properties with similar attributes, otherwise known as A. Comparables. B. Similars. C. Sames. D. Clones. Answer. A. Comparables, or comps, are the properties that are similar to the examined property that have sold recently. This gives the agent a good and fair determination of the current market value for the examined property.
Exam Scholar, Real Estate Edition.